Welcome, everybody. It's good to have you here with us on our Special Needs Trust Seminar sponsored by Interim Inc. My name's Deb Shearer, and I want to welcome you today. I'm going to be your host. I'm the Development Officer for Interim Inc., which means that it's my job to tell the wonderful stories of recovery of our clients and to keep connected with our fantastic donors. We also have live with us our moderator, Frank Hespy. Frank is an attorney and professional fiduciary and will be introducing each of our speakers as well as answering any questions you may submit. We'll explain how you can ask questions in a minute. Also with us today is Barbara Mitchell, the Executive Director of Interim Inc. Her decades of advocacy for adults with mental illness in Monterey County and across the state of California give her an expertise in this subject that few can touch. She will also be addressing questions from our audience. Here's what you can expect from this webinar today. We have 5 guest speakers who are all experts in protecting the rights of people with special needs. We will have question and answer periods throughout the webinar where Barbara and Frank will answer your questions. We will also provide you with a list of contacts and steps to take when preparing a special needs trust. So we have, like we said, we have 5 speakers today, and here's a list of who will be sharing with you. Our first speaker will be Carl Miller. He's a retired police chief, and he's also on the Interim Board of Directors. He's going to talk about 10 minutes. Carl's the parent of someone with a mental health diagnosis, and he and his wife have set up a special needs trust for his family member. He's also going to share why he and his family support Interim. Our second speaker today is Stephen Mudd, who's a private attorney in Monterey County. He's going to speak for about 15 minutes, explaining what is a special needs trust and how they should be used. Our next speaker is Christi MacDonald, the Deputy Counsel for Monterey Public Guardian's Office, Monterey County Public Guardian's Office. She will speak for about 25 minutes about the role of the public guardian and how conservatorships work. In case you're worried that there's too much information, we'll break in between each speaker with a chance for you to ask a question. Our next speaker is Liza Horvath, who's a private fiduciary here in Monterey County. Her name may sound familiar as she writes a column for the Monterey County Herald that addresses all kinds of trust questions. Liza will speak for about 10 minutes and will help answer the questions. Do we need a trust? If so, what kind of trust? Our next presenter today is the Honorable Vanessa Vallarta, who is here to give some perspective from the judicial side of this topic. Judge Vallarta will speak about the role of the courts, and she'll explain the types of cases she handles as a probate judge. And she'll give us 5 tips on how to have a successful experience in probate court. So before we go any further, I'd like to give our panelists a chance to say hello. Frank, can you say hello to our audience?
Of course. Hello, everyone. We're looking forward to giving you a great program today with a tremendous amount of information and being able to answer your questions. And we are so happy to be able to provide this very important information on this topic this afternoon. Thank you, Deb.
You're welcome, Frank. And Barbara, can you say hello to everybody?
Well, hi, I'm sorry I'm not seeing you all in person. I can see the names and I know several of you. And I look forward to post-pandemic when we might get together again.
Welcome to the Special Needs Trust offered by Interim Inc. My name is Frank Hespy. I am a local attorney and professional fiduciary. The purpose of today's seminar is to explain trusts and other options which are available to family members caring for a loved one who has special needs and may not be able to care for themselves. Today's webinar will explore a number of options available to family members. Among other issues that will be discussed by the panel today are special needs trusts. Special needs trusts are a specific type of trust which can allow a disabled person to remain on public benefits such as SSI or Medi-Cal while still receiving certain financial benefits from a family member or loved one through the trust. We will also be discussing regular trusts, or what are called inter vivos trusts. These trusts have less restrictions on how the funds can be used for the beneficiary, but sometimes they can also affect that person's ability to be on public benefits. For some families, availability for public benefits is paramount in the planning, and for others it is less so. We will also be discussing conservatorships, the role of courts, and other governmental agencies. It is very important that the tool of a conservatorship is available, and again, for some family members, that's quite important, and in other situations, less so. We will also discuss other financial and practical options that are available and the important role that professional private fiduciaries can play. Sometimes, often, it's a family member who will take the lead in managing these funds, but in other situations when a family member is not appropriate or is not available, there are professional people that are able to do that. Overall, we will be covering legal, governmental, judicial, fiduciary, and other very personal and important topics in today's seminar. I do want to add that we cannot cover all of the pertinent topics and that this seminar is not a substitute for you talking to your own attorney or professional fiduciary. We urge you to sit down and talk about your specific family situation with a professional person as you move forward. Today we have an excellent panel joining us, and I want to thank each and every one of them for devoting their time and energies as volunteers on this very important topic. Today's topic is of great value to our society, and I thank each and every volunteer for taking the time with us today. Joining us today is Carl Miller. He is the immediate past board president of Interim Inc. He is a retired chief of police of Pacific Grove, California. He has great experience as a family member of someone serving with mental illness, and will talk about his experience on a personal level with us today.
Hello, my name's Carl Miller. I've been on Interim's board of directors for probably 13, 14 years now. One of the main reasons why I'm on Interim's board is because of my son, who suffers from bipolar. And we have a special needs trust. And I have some questions here. One is, why a special needs trust? So we actually developed our first trust 20 years ago when our boys, we have two sons. One was 14 and the other was 12. And at that time, our oldest son was not diagnosed with bipolar. That diagnosis probably happened 5 years later. So at the time, we were more focused on if my wife and I were to pass away before our sons when they were young, who would take care of them, how would we handle the finances that we are leaving them. So we decided we needed a trust, really, to look out for them. And like most parents, you don't want to leave all the wealth you've accumulated in the hands of a 12-year-old and a 14-year-old. So you create a trust that someone would look after that. And in our case, it was until both of our children turned 30 years, and then they would get any money that was left in the trust. About 5 years after that, our son was diagnosed with bipolar, and it was probably 10 years ago that we decided we needed a special needs trust, and we did an addendum to our original trust for our son. People ask, why do you need a special needs trust? Well, one of the main reasons why people tell you is it allows your family member, if they're getting resources like SSI, like our son is, and Medi-Cal, that they can continue to receive that and then have access to any wealth that you've accumulated, as long as it's used for special things. And this is a real specialty in the law, that you really need somebody to look out for that. There's a second reason for my wife and I. Let me give you a little bit about my background. I was a police officer for 30 years. And it's hard to imagine how many times police officers come in contact with people that suffers from various degrees of mental illness. And one of the things that usually led to those encounters, and here's another misnomer, people have people believe that people suffering from mental illness are usually causing crimes or perpetrating crimes. Couldn't be farther from the truth. They're usually the victims of crime much more often than they're the perpetrators of crime. But one thing I sort of noticed with all these encounters that police have with people suffering from mental illness is that support network that that person had somehow disappeared. And usually it disappears with a death. Usually it's women outlive men. That's statistically just the way it is. Go to any nursing home and you'll see that they're filled with women, more likely than men. And so usually it happens with the death of the mother, and it leaves this family member with the vital piece of their support network gone. So the main reason I see for a second needs trust is to keep that support network intact. And how it should be, it really should be seamless. When the last of the parents pass away, there should be everything in place to take over and keep things in continuum going. Probably one of the biggest things that you need to concern yourself with is who's going to administer this. And this is and who's going to write this special needs trust for you. One, you have to find a lawyer who specializes in this. That's very important. So you're going to have to do your homework. Fortunately, Interim, we've done a little bit of the legwork, and we can help you with recommendations on lawyers to see. You're taking an important first step by looking at this video, because obviously you realize that you need something in place. So this is the first step, but it's by no means the end result. Interview the lawyers, see what their expertise is, talk to groups like Interim to make recommendations of lawyers that have this type of experience that you need. And one question you're going to have is who administers this this trust. And we chose my wife's younger brother. But that was done for our first trust, for the financial end of it. And the thought was once our kids turned 30, if we had passed early, then they would be able to access their own money. But in the case of our son, our family member, our son who has bipolar, that really wouldn't work. To give him money all at one time, probably not a good idea. You need somebody to look after to make sure the wealth you accumulated will last and serve them through their lifetime. So it's important to have an administrator. We picked my wife's brother, but I think that's an area we need to revisit. I think it's wrong to have family members provide that function, because whenever you talk about money, you're going to have to say no to some things. My son has a younger brother who could step in, but I want him to be more of an advocate for his brother and not someone that's administering this. So one thing that we're going to do is try to find an administrator to pick up when my wife and I are no longer there to help. And this is very complicated because the wealth you do have, you want to be invested, and that takes a certain skill level. And then just staying on top of the law. Right now, the law allows for things like medical expenses, transportation, education, entertainment, and travel. You can spend out of a special needs. Doesn't cover housing and food, and does cover medical that's not covered by government resources. But this law is constantly changing, so you need somebody who stays abreast of the law, keeps the trust out of trouble. So you really need to do your homework on that. And again, turn to groups like Interim that provides support. One question is here, how does it help the beneficiary? Well, again, it just has that support network in place to pick up when the parents are no longer there to do that. The other thing is you really need to talk to your family member, let them know what's coming, talk to all the beneficiaries so everybody understands how the special needs trust work and what it can do and what it can't do. That's very important. What did I wish I knew when I established a special needs trust? Well, like I said, we had already established a trust, and then we knew we needed a special needs for our son. Probably just taking the time to interview lawyers, to interview administrators is the one piece of advice that I would recommend. What advice would you give to a family member who is planning the needs of a beneficiary? Well, like I said, do your homework, talk to groups like Interim. You're taking the first step by looking at this video, but it's only the beginning. This is a specialty part of the law, and it does take a certain amount of expertise. A little bit about Interim. Interim, we go back 45 years. Again, when I was a police officer, didn't really know about Interim. I found out about Interim because we had a call to a house in the city I was working that was run by Interim. And we were able to take care of the problem. It wasn't that big of a deal, but that was probably the first time I heard about Interim. As I went on in my career, and then after my son was diagnosed with bipolar, I got to know what Interim does, and we do a lot. 45 years ago, we were mainly concerned with helping housing for people with mental illness. But now our focus is not only housing, but supportive services. We also do a crisis intervention, and we do dual diagnosis for people that suffer from addictions, either alcohol or drugs, and mental illness. We provide employment services, and in just about all the areas that affect a family member that would be suffering from mental illness. And this is just another area that we identified is setting up trust to help those family members that suffer from mental illness into the future. And Interim provides that support on so many different levels. And if you're anything like my wife and I were when we were first confronted with this, you probably have a lot of questions. And Interim can provide those answers for you. So I encourage you to reach out to us. I encourage you to assist us. Another thing about Interim is where we draw funds. We draw funds from a variety of sources. They come from federal, state, county monies. But all those monies come with conditions. We're only allowed to spend those funds on certain things. So we do get involved in fundraising efforts, but that's primarily designed to fill in those areas where we're prohibited from spending money. And there's so many needs for that. If, however, Interim can be of assistance, I encourage you to reach out to us. Good luck with your family member. I hope that things work out, of course, but I hope you're able to put something in place that will take care of them and be there for them in the future when you're not. Thank you.
Okay, thank you, Carl. We've got a couple of questions from the audience. Are you there, Frank? Can you help us answer what is a fiduciary?
Yes, I'm here. I apologize.
That's okay.
Yes, I'm happy to answer that question. A fiduciary the term fiduciary is used in many different ways. The way we're using it today is primarily as a trustee of a special needs trust or a regular trust. Generally speaking, a fiduciary is somebody who is responsible for managing somebody else's money, and they have a duty to the beneficiary to use that money wisely and to keep it safe. Thank you.
Thank you, Frank. Another question we have here, does everyone need a special needs trust? Frank, I think that's yours too.
I think so. The answer is definitely no. And as we're going to see over the next hour and a half, the next presenters will explain to you the pros and the cons of a special needs trust. And at the end, you'll have a much better sense on what you individually need. Thank you.
Thank you, Frank. Let's go to the next speaker.
Today with us, we have Stephen Mudd. Stephen is an elder law attorney with the law offices of Hempel and Mudd. His primary area of practice is estate planning, special needs planning, conservatorships, probate, and Medi-Cal. Prior to joining Hempel, and Mudd, Mr. Mudd worked for the Monterey County Adult Protective Services, where he specialized in investigations and elder financial abuse. He also worked for Monterey County Child Protective Services, the Office of Education, Housing Authority, and San Diego County Mental Health Department. Mr. Mudd has a law degree from the Monterey College of Law, and he has a Master's of Science degree in counseling psychology and has conducted clinical research in schizophrenia and other psychiatric disorders at both Northwestern University and the University of California at San Diego.
Hello, my name is Stephen Mudd. I'm an attorney. I practice in the areas of estate planning, which includes trusts and wills and special needs trusts. I also do probate, conservatorships, so a lot of elder law issues. Today I'm going to be talking about special needs trusts. Special needs trust. So why would somebody need a special needs trust? When would somebody need a special needs trust? Generally, special needs trusts are extremely important when somebody is receiving needs-based public benefits, or they may need public benefits in the future. Public benefits, most importantly, include SSI and Medi-Cal. And as many of you may know, those are based on low income. So you have to have low income, low resources in order to qualify. And specifically with both SSI and Medi-Cal, you can't have any more than 2,000 in countable assets, countable resources, to be eligible. So what happens is that if you give somebody money, whether it's through a will or a regular trust, what happens? All of a sudden they have a big influx of funds, and immediately they're going to become ineligible for public benefits. And losing SSI is bad. You're losing money every month, but losing Medi-Cal can be devastating. You know, people, not only the medical services that it provides, but also, the social services, the in-home supportive services, services that are provided through regional centers, San Andreas Regional Center here in Monterey. So it's really critical. And what a special needs trust can do is, rather than giving the money directly to your child or grandchild, you have that money go directly into a special needs trust. And that way those assets do not count. They don't count toward that $2,000 that that person is allowed to have. So you can use the money in a special needs trust to better that child's life while still maintaining eligibility for public benefits. So it's a really useful and critical tool for people. Special needs trusts are different than ordinary trusts because they contain certain language that Social Security comes to expect. So if Social Security learns that you're the beneficiary of a regular trust, there's oftentimes a knee-jerk reaction to discontinue benefits. And once you're kind of in that discontinued path, it's very difficult to challenge and fight with Social Security and get that resolved. So special needs trusts contain special language that they expect that lets them know very clearly that this is a special needs trust and it should not be counted as the beneficiary's current resources or assets. So if not drafted correctly, Social Security and Medi-Cal may count those assets in the trust as part of their assets and deny benefits. So it's very important. All right, so there are generally three types of special needs trusts. There's a first-party special needs trust, a third-party special needs trust, and a pooled special needs trust. The best kind are the third-party special needs trusts, and that's where somebody kind of has planned ahead. So the most important part of a third-party special needs trust is that it's funded with assets that do not belong to the beneficiary. Okay, usually they belong to a parent or a grandparent. The grandparent or grandparent creates their own trust, and within that trust they specify that the assets are not to go directly to the beneficiary. They're supposed to go to a trust, to a special needs trust for the benefit of the beneficiary. And that is really critical. The big difference between a first party and a third party special needs trust is the fact, again, that they're not assets that ever belong to the beneficiary. The beneficiary never had a right to receive those, him or herself. The difference as far as consequences is that when if there's money left over at the death of the beneficiary, There's no Medi-Cal payback requirement. So that's the big difference between a first party and a third party. A third party beneficiary, a third party special needs trust, when somebody dies, the beneficiary dies, whatever's left in that trust has to go to pay back all the services that were received through Medi-Cal. There's different ways to draft a special needs trust. A special needs trust can be included in the person's own trust. So it's like a provision within their own trust to create this special needs trust, or it can be created as a standalone special needs trust. And they both work just fine. The difference between having a trust built into, a special needs trust built into your own trust versus a standalone is that a standalone trust can anytime receive gifts. So if a grandparent wants to gift money, they can give money directly to the special needs trust. And you can name that special needs trust as a beneficiary of a life insurance policy, a retirement plan, or something like that. So it's pre-existing standalone special needs trust that anybody can really put money into at any time. So there are some limitations to a special needs trust. First of all, you need a trustee that's willing to do the job. And sometimes that's not easy to find. The beneficiary, him or herself, cannot be the trustee. Also, they can have no authority, no power to revoke the trust. So you really need somebody that you can trust that's good with managing money, that can manage this money for this person over the duration of their lives. You can also name backup trustees. You can even have a provision in the trust that if the trustee can no longer do it, that they could actually name a replacement, which is an important thing to have in there. Otherwise, you end up having to go to court to have a trustee named. Most importantly, the funds should not generally be used for food and shelter. And that's what is referred to as in-kind support. And that will reduce the amount of SSI that child receives. It's worth the trade-off. You want the child to have a better place to live, so you contribute some money toward housing. The SSI amount will go down to a maximum of around $277 or so. But once you hit that maximum level, it's not going to go down any more than that. Another big limitation on special needs trust is that you should never give cash to a beneficiary. A cash gift from a special needs trust will cause SSI to go down dollar for dollar. So if you give $1,000 in cash, your SSI is going to be wiped out. Also, if you're on Medi-Cal and you give cash, that's going to increase the share of cost for that child for benefit, for medical services that they receive or social services. And one big thing with a third-party special needs trust, as I said before, that is money that belongs to somebody else that has funded that special needs trust, and you have to keep those funds separate from the beneficiary's income. So their Social Security, their SSI, whatever other money they get cannot be part of that third-party special needs trust. Now we're on to first-party special needs trusts. Those are also known as a D4A trust, and that's because of the federal law that enables you to do this, to create these kinds of trusts, also known as a self-settled special needs trust or a litigation special needs trust. And these are funded with assets that actually belong to the beneficiary. So it's their own money, so to speak. So oftentimes this comes where nobody did any planning ahead of time. So let's say, the parent, the mother or father, the parents had a trust or a will. They specified that, the child is to receive an inheritance, half of the estate or whatever the case may be. All of a sudden you're in big trouble. So you have this money that's supposed to go to this child, but if the child receives the money, they're going to lose their benefits. At that point, it's already too late. That child has a vested interest in that trust or in that will, whatever the case may be. So you can't simply just say, oh, we're not going to give the child the money, the child will never get it. You can't do that. That money, that horse has already left the barn. That money is earmarked for that child. It's their money, even though they haven't received it yet. So what you do is you basically try to clean it up by creating a trust after the fact. And so, like I said, these funds are normally come from an inheritance, a life insurance policy that named that child as a beneficiary, or oftentimes a personal injury reward. So there's a lawsuit or something, the child was injured, and they stand to receive a settlement amount. So what you do is you create this third-party special needs trust, and you have that money transferred into that first-party special needs trust. There are some additional scrutiny from Social Security and Medi-Cal regarding these trusts, but they're perfectly legitimate and they should protect that child's public benefits. First-party special needs trust in federal law, it states how and who can create these. So they can be created by a parent, a grandparent, guardian, or conservator, or the court. As of 2016, December 2016, they can also be created by the beneficiary themselves, him or herself, as long as they have capacity to do that. So if they're mentally clear, they know what they're doing, they can actually create this first party special needs trust by themselves, which is actually very useful because oftentimes you don't have a parent or a grandparent available to do this. Basically, because first party special needs trusts are funded with a beneficiary's own money, they're scrutinized more closely by Social Security, and they have more restrictions. They can only be created for somebody who's under age 65 and are disabled. Okay, and that's not the case with a third-party special needs trust. Okay, so that's when people come to me and somebody's supposed to receive money, they're disabled, but they're over age 65, you cannot do a first-party special needs trust, it's too late. You can't add to a special needs trust after somebody turns age 65, so that's just something also to keep in mind. The income that's generated within a trust after age 65, that's okay. You just can't put outside resources into a first-party special needs trust after age 65. Okay, first-party special needs trusts also must be irrevocable, and most importantly, they must contain that Medi-Cal payback provision, and that has to be very pronounced within the trust so that Medi-Cal can see it when they review the trust. And it very clearly says before anybody, when the beneficiary dies, before anybody gets anything, Medi-Cal gets paid back for whatever services they provided. And so that's, like I said, a big distinction between first and third party special needs trusts. That's why it's very good to kind of plan ahead and get that third party special needs trust set up ahead of time. So there's also first party special needs trusts if they're created by the courts. Most commonly, what I do conservatorships. So, we do what's called a petition for substituted judgment to create a special needs trust. And in those kind of situations, there are additional requirements that the court imposes. Oftentimes, the court requires mandatory accountings for the trustee of the special needs trust. You usually have to do them after the first year, and then at least every 2 years after that, you have to account for every penny to the court. And, and that adds additional, attorney's fees and costs. So it's another real good reason to plan ahead and, like I said, get that third-party special needs trust set up early. Okay. Also, with a court-created special needs trust, they often require the trustee to have a bond, and that is just an additional expense. It's like insurance for the trustee in case they do something wrong, in case they, steal money or something like that. The beneficiary is protected. In addition, finally, attorney and trustee fees must be court approved. So you actually have to file a petition, usually as part of the accounting, requesting that your fees be granted, that you can pay yourself as trustee and pay the attorney for the services that they provided. Okay, finally, there is what's called a first-party pooled trust. The most important distinction about these, it's administered by a nonprofit association. What they do is they pool all the resources of a bunch of beneficiaries together and manage them as a collective. So they can be joined by the beneficiary, parent, grandparent, legal guardian, or the court. And one of the most, they're really, for me, they're most useful when somebody is over age 65. Because they don't have that requirement that you be under 65 to enter or join a first-party pooled trust. Also, it can be very useful if you can't find a trustee that is willing to do the job or able to do the job. You can join a pooled special needs trust, and they have those services built in, so they automatically will act as trustee for you and distribute the money to the beneficiary. They're aware of all the rules regarding distributions for food and shelter and those kinds of things. So they're they know what to do, and they're fairly efficient. The only negative really for those are they tend to be a little bit more impersonal. They're dealing with a lot of beneficiaries, so they're usually good at kind of distributing checks. But more complex cases can be difficult. They tend to be a little more inflexible for that reason as well. And there are some costs associated with doing those. And that concludes my presentation. Thank you very much. I appreciate the opportunity to be here. Thank you.
That was a ton of information. Frank, we've got some questions that are coming up from our audience. The first one is, if someone is currently on SSI or SSDI, is it possible they would be on SSI in the future?
If I understand the question, yes. If someone's on SSI now, they may be remaining on SSI for the rest of their lives. A special needs trust is a way of getting extra money and remaining on SSI, if that was the question.
Okay, the question was about SSDI.
Oh, I misunderstood. So
That's okay.
SSDI is Social Security benefits. SSDI is not income-based, so you can get SSDI and still have as much money as you can. So you would not need a special needs trust if you are on SSDI. I guess it's possible you could be on SSDI now and go to SSI, but usually the SSDI income level is higher than the SSI amount. Again, these are complex questions, and we may not be able to get into a full analysis here during this webinar.
Thank you, Frank. Still on questions about SSI, does SSI also have to be paid back if they inherit money or a house?
If we're talking about general paying back and that it has nothing to do with a trust, then generally the answer is no. That if you are on SSI and you've been getting benefits for a while, if you inherit assets, it will probably kick you off of SSI going forward, but generally you would not have to pay back the SSI benefits you received in the past. Thank you.
One more question here, Frank, and this one we knew was going to come up somewhere. What does it usually cost to set up a special needs trust?
That is a great question. Every lawyer will charge somewhat different than everybody else. Here in our local community, probably $2,000 to $3,000 is the average cost that an attorney would charge to do the legal drafting of the appropriate documents. So it is something that's important to be cognizant of, and it is a function of how much money you plan on putting into the special needs trust. Thank you.
Okay, I have one more question for you, Frank. This sounds pretty specific, but maybe you can just give us a bird's eye view answer of it. The question is, let's say the beneficiary has a special needs trust established by a parent, and the parent dies with the special needs trust in place, but later the beneficiary is in an accident and becomes a recipient of a personal injury award and establishes a first-party trust. Are both trusts legally viable?
That's actually a great question. It could be a law school kind of question, so I appreciate it. And so the simple answer is yes. A beneficiary can be the beneficiary of both a regular third-party special needs trust as well as a first-party special needs trust. So there's absolutely nothing that prohibits a person from having money in two separate trusts and receiving benefits accordingly. Each of those trusts, as Mr. Mudd explained, have their own limitations that have to be taken into account in that situation. Thanks, Deb.
And I have one more, and then we'll go on to the next segment. Beyond the drafting, how much help does it, if any, does the attorney give for the decision process about how to set up a special needs trust?
Well, a good lawyer will absolutely explore with any client the pros and cons of a trust. We'll explain how a trust is funded. We'll very much talk about the limitations and how to run a special needs trust. In truth, once a trust is established, then it falls to the trustee, generally not the attorney, to be able to manage the trust and to follow all of the legal requirements thereto. Okay.
All right, thank you, Frank. Now we'll go on to the next section.
Next with us today, we have Christi MacDonald. Christi is an attorney and a deputy county counsel representing Monterey County Public Guardian, Public Administrator in both mental health and probate conservatorships. She is responsible for advising on all aspects of conservatorships and estate administration for the Public Guardian's Office. The Public Guardian's Office offers services as a public conservator for persons who do not have anyone else willing or able to serve as their conservator. Christi is passionate about providing services to the most vulnerable members of our community and making sure that everyone has access to appropriate housing, medical care, and financial support services.
Hi, thank you for joining us. My name is Christi MacDonald. I'm a Deputy County Counsel for the Monterey County Public Guardian, and I've been doing that for about 3 years. I work with probate conservatorships and the LPS mental health conservatorships. That's my background, and that's the focus of my topic today. So I want to start with, what is the Monterey County Public Guardian? The Monterey County Public Guardian acts as a conservator of last resort for people who don't have a willing and able friend or family member to act as a conservator for them. They are the conservatorship investigator for all of the LPS mental health conservatorships in Monterey County. They are the only agency that has the authority to do those LPS mental health conservatorship investigations. It's also the only entity that has the legal authority to file an LPS conservatorship. It's the only entity that can serve as a temporary LPS conservator. The Public Guardian also acts as a representative payee for Social Security benefits and a VA fiduciary for VA benefits for patients of Monterey County Behavioral Health, and also any of our conservatees under the probate code. For a representative payee, an individual does not have to be conserved, but they would have to be connected to Monterey County Behavioral Health. And sometimes a representative payee is enough to help protect an individual's finances, enough to give them that additional support so that they don't actually need a conservatorship. Monterey County Public Guardian also works very, very closely with our partners, various social services agencies, behavioral health, adult protective services, the mental health unit over at Natividad, and Garden Pavilion at Community Hospital. And we work together to ensure that residents of Monterey County have these additional supports available to them. And of course, we work with Interim Inc., who's sponsoring this. So what is a conservatorship? A conservatorship is a legal process where you ask the court to give a responsible person authority, the legal decision-making authority, over another vulnerable individual who is unable to handle the basic tasks of daily living and or their financial situation. So the conservatee is the individual who is unable to care for themselves, unable to protect themselves in terms of providing food, clothing, or shelter, or unable to protect themselves financially from undue influence or other things like that. The conservator is the person the court selects to appoint to make those decisions for the conservatee, the vulnerable individual. And the conservator, their primary guiding principle would be to act in the best interests of the conservatee. So there's a couple of different types of conservatorships. So one is a probate conservator of the person, and that person is appointed to take care of and make decisions regarding the daily needs of the conservatee, including ensuring that they have access to medical care, that they have food, that they have clothing, that they have shelter, that they have those very basic day-to-day needs taken care of. There's a probate conservatorship of the estate, and that is somebody who takes care of all the money and protects the conservatee from financial abuse. There's limited conservatorship of the person and or the estate. So Limited conservatorships are a special carve-out type of conservatorship that is for somebody who has developmental disabilities, and that they would work with San Andreas Regional Center to get that kind of a conservatorship established. And the goal of that type of conservatorship is to make sure that the developmentally disabled adult is able to be as independent as feasible based on their specific circumstances and needs. So it's just to provide, kind of shore up that person, you know, make them as independent as possible, but with the support of a conservator, and usually the regional center as well. And then the last type is the LPS conservatorship, and those are our mental health conservatorships. Those are exclusively for individuals who suffer from serious mental health disorders, such as schizophrenia, schizoaffective disorder, bipolar, major depressive disorder with psychotic features. Typically, those serious, pervasive mental illnesses involve some psychotic features, but the law is pretty broad as to exactly what falls within, but those are sort of the bread and butter kind of diagnoses that we see for our LPS clients. And the reason that the court would appoint an LPS conservator would be that the person is unable, due to their mental illness, to provide for their food, clothing, or shelter as a result of that mental illness. And the powers in an LPS conservatorship allow placement in a locked psychiatric facility and for psychiatric medication to be administered. So comparing probate conservatorship versus LPS conservatorship. So how do they start? So a probate conservatorship can be started by any interested party. That's a family member, that's a friend, that's the conservatee themselves. If they recognize, hey, I need help, I'm not able to do this, they can petition the court themselves to ask for a conservator to be appointed. So anybody who has some relationship with this individual who needs help can file a probate conservatorship. LPS, only the public guardian, and that is very much the role of the public guardian. That is what I do most every day. So the duration of the conservatorship differs between a probate and LPS. Probate conservatorships, once their conservator is appointed, they continue on indefinitely until there are facts that would warrant termination of the conservatorship. Again, probate tends to be our older population who maybe have dementia, and they're not likely to regain capacity necessarily, or it's an individual who's maybe developmentally disabled and isn't likely to suddenly be able to manage all of their own affairs. In contrast, an LPS conservatorship, our mental health conservatorships, are in 1 year increments. So with mental health, you hope that with medication, with therapy, with the support of our behavioral health partners, Interim, these sort of community resources, that a person who might initially be in crisis will be able to develop the skills of self-care, understanding the importance and role of medication and therapy, might be able to not continue to need the support of a conservatorship for long term. So the law recognizes that you can get better and that you can manage your symptoms, and that conservatorship for mental health is limited to 1 year, subject to a new showing that the person still needs it. So the types of medical powers are different as well. So in a probate conservatorship, you can get general medical powers to make all medical decisions for the conservatee. In LPS, those powers are very limited. They are limited to making psychiatric medical decisions and to routine medical decisions, such as the person needs to take cholesterol medication every single day. The types of placement are different in probate conservatorships. Probate conservatorship, you can have somebody in their home, you can have somebody in residential care facilities, board and care, skilled nursing, and pretty much whatever you can think of, as long as it's not a locked psychiatric facility, you can probably make that placement work under a probate conservatorship, with the exception of dementia placement, which you'd need special powers for that. Under LPS, also tons of options available, but it also includes the ability to place somebody in a secure psychiatric facility, which would be a locked type placement, including state hospital or an institute for mental disease, sometimes called an IMD. Probate, you can have person and estate. You can have just person powers. You can have just estate powers to manage the money. LPS also has person and estate, but typically you would see an LPS of the person and not LPS of the estate, but you can technically have it. Most clients, a representative payeeship is enough to take care of their financial needs without the need for the conservatorship of the estate in LPS. So what kinds of decisions can a conservator make? So you can make personal care and medical decisions. So that's making sure that they have their personal needs for food, clothing, bathing, shelter. So that's selecting their medical providers. That's selecting the caregivers that maybe come in and provide services to them. What kind of medication should the conservatee take and which should they not? What kind of medical procedures should the conservatee have and which should they not? Should they have a second opinion? Those sorts of things are the powers that a conservator of the person would get to make. They can obtain health insurance and other health-related benefits for them. And you have access to medical records. And I know on the LPS side, many families are frustrated with the inability to access medical information for their mentally ill family member or friend because they don't know what's going on. So sometimes a conservatorship gives you those medical powers and gives you the access to information, which can be very helpful and comforting. A little caveat here, limited conservatorships, the powers can be a little bit different. They're set by the court. So again, I'm not talking about those, but just to know they're a little bit different depending on what the court does. You can determine the living arrangements for the individual. So what's the appropriate level of care? Can they live in a home? Can they have independent living? Do they just need somebody coming in a few hours a day? Or do they need to live in a placement of some sort? So a conservator would get to make that kind of a decision. And then for conservators of the estate, they get to make those financial decisions, those contractual decisions. So they control all the money. They, can go take over bank accounts. They can take over pensions. They can take over other accounts that the person might have. They can step in on leases, for example, and negotiate with landlords and things like that on behalf of the conservatee. You are literally standing in the shoes of the conservatee. So there's a couple of pros and cons of conservatorship. So certainly the advantage is that it offers a lot more protection because it's court supervised to the conservatee. So you're not just having somebody act on behalf of the conservatee, but you're actually having that person's actions reviewed by the court. And while I would love to believe that everyone in the world always does the right thing, sometimes people who have a lot of power and they have access to money and they have access to resources of another person suddenly go, well, I need a little bit of this, and maybe that money gets loaned to me. Or maybe they get a little bit of loosey-goosey on how they're maintaining the books. And somebody who's a conservator who has to report every single penny to the court and how it's spent and how that money was for the benefit and only the benefit of the conservatee, those people tend to actually do the right thing most of the time. Those who know that nobody's looking at what they're doing, sadly, that's most of our adult protective services cases that involve financial abuse. It's usually a family member who's financially abusing somebody else, and it's very sad. So one of the biggest things that I like about a conservatorship is it has court supervision to make sure that that person is accountable and that the conservatee is protected. So another benefit is the conservator who's competent, who's able to advocate on behalf of this conservatee can get benefits in place for the individual because the individual wouldn't be able to do it themselves. So they can usually get those services much more quickly. They can act to protect the assets, pay bills, manage any investments, those sorts of things. They can help the individual who wouldn't be able to accept assistance voluntarily. And then, of course, going back to court supervision, I love court supervision. I think it's a very powerful tool for making sure that our most vulnerable are protected. So some of the disadvantages of a conservatorship. For private conservatorships, certainly the cost. Unfortunately, attorneys like me charge for our services. And we play a very important role, but our services are not usually, inexpensive. So that can be a challenge. Filing fees for the court, investigator fees, all of these fees can add up. There are court waivers for filing fees and the investigator fees, so please don't let the potential cost dissuade you from getting a conservatorship if that's really what's appropriate for your situation, but it is potentially a downside. Some of the records in conservatorship cases are public. In a probate conservatorship, for example, the petition is public. There are confidential documents, so not everything is public. The investigator report is confidential and only available to the parties. Mental health conservatorships are entirely confidential proceedings, so it's less of an issue in mental health. And then the last disadvantage, which is very important, is it does restrict an individual's personal liberties to make their own medical decisions, to make their own financial decisions, to choose where they live. And these are some very fundamental rights that we all hold dear. And so this really is the last option to consider because it really does take away some important rights. But there are definitely very compelling cases why that's appropriate and in that person's best interest. And of course, with great power comes great responsibility. So if you act as a conservator, you have a lot of responsibilities, and it is a lot of work. It's very rewarding work, but it is a lot of work. So some of the responsibilities of a conservator of the person would be to arrange for the conservatee's care and protection, to decide where the conservatee will live, to make arrangements for meals, health care, clothing, personal care, housekeeping, transportation, shelter, and for the conservatee's overall well-being. You are responsible for this person and making sure that they are okay every day, 24/7, 365. So it's a big responsibility, but also very important. Some decisions require you to get court approval. So that would be, where you would work with your attorney to find out, do I need court approval for this or that? Sometimes to move somebody, you would need court authority. To sell their home, for example, you would need court authority in many circumstances. And then you also have a duty to report to the court on the conservatee's status, typically after the first year and then every 2 years thereafter. Conservator of the estate is, you have to manage the conservatee's finances, you have to find and take control of all of the conservatee's assets. Super easy if you know where this person keeps all their money and all of their accounts. Public guardian, we definitely have a challenge on this because sometimes people come to us, they can't speak. We don't have any family or friends around, and it's quite the treasure hunt to try to find where they banked. Sometimes it's literally just going bank to bank. Hey, Bank of America, does this person have an account? Nope. Okay, Chase, does this person have an account? And that's what you got to do. If you're the conservator of the estate, you got to go find that property wherever it is and take control of it and protect it. You have to inventory and get an appraisal for all of the property of the conservatee and report that to the court. You need to make a budget showing what the conservatee can afford and what, how their income and their assets are able to cover the cost of their care. If the cost of care exceeds their resources, you need to plan for, getting them public benefits that can meet their needs. You need to pay the conservatee's bills, and you would need to responsibly invest any assets that they have to make it productive for the conservatee's benefit. You're protecting their assets, and then the paperwork. you got to report all of this to the court in what's called a court accounting. And that, again, is every single penny that's spent, every single dime that is collected, every asset that you've collected, all of that needs to be on an accounting and filed with the court and served on all the parties. When you're considering a conservatorship, you have to really ask yourself, is a conservatorship going to solve the problem that is arising that's making me think about conservatorship? So you're always looking for the alternatives. Is there some less restrictive alternative that might fix my problem? So some of the alternatives to conservatorship that you might want to try ahead of time if the person has capacity would be a durable power of attorney, sometimes living trusts or special needs trusts, or a money management option like a representative payee or a VA fiduciary for VA benefits. And then this is a challenge that we run into with our LPS mental health conservatorships a lot, is that even though we have medical powers, we don't necessarily, we have the ability to sign a piece of paper that says we consent to a certain medication. But that doesn't mean that an unwilling patient is going to swallow that medication. Now we can get creative in our higher level care. If it's a pill, sometimes they can crush it up and put it in their food and, you know, to get it in sort of whatever way they can. But in a lower level of care, they can offer the medication. If the individual doesn't take it, they don't take it, and they can't physically, you know, force them, like at a board and care, for example. So sometimes having the power doesn't solve your problem. So it's important to ask that question before you go down the path of getting all the legal paperwork in place and then find out this didn't fix your problem. So then you also want to ask what kind of conservatorship is needed. So it is possible to have both a probate conservatorship of the person and estate and an LPS conservatorship as well. So we have several of these cases at the Public Guardian's Office where the individual probably has a serious mental health disorder, but they also probably need more support than just the mental health piece. They need support on their estate side. They need general medical powers as well. So sometimes we'll open both kinds of cases to just, if you imagine the powers of a conservator are all a bundle of sticks, we gather up all the rights, all the sticks that you can get with all the different powers, and we bundle them together so that we can take care of the entire person and all of their needs. But you don't necessarily need all the powers in the world. Again, it's got to be focused on what does this individual need. You should consider an LPS conservatorship if you answer yes to any of the following questions. So does the person have a serious mental health disorder, again, typically schizophrenia, schizoaffective, bipolar, which prevents the person from obtaining food, clothing, or shelter? Then you also want to ask, does the person decompensate when they discontinue taking their psychiatric medications? And does the person require a secure psychiatric placement such as an Institute of Mental Disorder or IMD? So you cannot go to an IMD if you do not have an LPS conservatorship in place. That would definitely be something that you would be looking at if they needed that very intensive treatment. You should be considering a probate conservatorship if the person is unable to manage their personal or financial affairs for any reason. Medical condition, cognitive issues due to age, developmental disabilities, that would be a limited conservatorship, traumatic brain injuries, those types of issues. I will point out that for LPS, it is strictly mental health disorders. The code does exclude, statutorily exclude, an LPS conservatorship for somebody with a developmental disability alone and a traumatic brain injury. So those are carved out. LPS is not appropriate for somebody who's developmentally disabled or a traumatic brain injury. So you'd be looking at a probate unless they also had a co-occurring mental health diagnosis like schizophrenia. So you're looking at probate conservatorship if the person requiring assistance does not have capacity to make any decisions, and that there are no less restrictive alternatives. That would be your power of attorney, your advanced healthcare directive, your trust, those sorts of things. Thank you so much for watching. If you have any questions, please feel free to direct them to development@interiminc.org.
Thank you for all of that information. That's a lot of information. We have a few questions. The first one I have for Barbara. Are you there, Barbara?
Yes.
Hey, okay. Barbara, in your experience, what are some of the pitfalls of not having a special needs trust when the beneficiary of the trust is on SSI or SSDI or other public benefits?
Well, we've had clients who have received, who have been given a bequest that involves something like a pension plan that has just enough income to make them ineligible for SSI but doesn't have enough money to actually replace the benefits that they have. So we've had people who have received this and are suddenly ineligible for affordable housing or for any kind of housing subsidies. It's really important if you have income and you want to leave your family member or someone else some type of bequest, that you make sure that you are leaving them enough money to replace what public benefits they may lose. Thank you.
Thank you, Barbara. We have a couple of questions for Frank from our audience. Who sets up a durable power of attorney and what provision does it provide?
Sure. There are two types of powers of attorney. One is for financial and the second is for healthcare. Both of them requires that the person sign it themselves. And so if a person is legally competent, then they can sign it now, giving authority to somebody in the future to handle either their healthcare or financial decisions if they cannot take care of themselves at some point in the future. These documents are usually drafted by an attorney, but there are some pre-printed forms that can work adequately in certain situations. Okay.
Thank you, Frank. The next question we have is about what a special needs trust money can be spent on. The viewer wants to know, can special needs trust money be used to pay property taxes and home maintenance?
That actually is a great question. The rules about what the money can be used for are very specific. They're buried deep in a statute, and I have to admit, sitting here today, that I have not memorized that statute. Generally, it cannot be used for food and shelter. It's an interesting question whether taxes or mortgage or other things connected to real property, either I or an attorney would need to go get into the weeds to answer that question for the person. Okay.
Okay, thanks, Frank. Here's a question. Does a trustee have to report what is spent from a Cal Able account?
I have to admit, I don't know what a Cal Able account is. I'm guessing it's some type of a pension coming from the state of California. It depends on what type of a trust you have. Generally, a regular special needs trust is not under court supervision, so no one is reporting to the court system, but most special needs trusts that are drafted well will say that there should be an annual accounting to the beneficiary or to some other third party. I don't think pensions are separated from whatever the normal requirements are for accounting that is written into each different special needs trust. Okay.
Okay, one more question and then we'll go to the next segment. How do you set up a trust with spouses' assets?
Generally, it would be the exact same mechanism. If the spouse is, of course, still alive, then that spouse has control of the assets, and he or she can create their own trust, or they can transfer or will their assets to somebody else's trust. Generally, a spouse is seen as the same as the husband or wife would also seem. So that's the basic structure. Again, as we've said many times, consulting an attorney about your specific situation is the only way to make sure you get a complete and full answer to these types of questions. Thank you, Deb.
Okay, thank you, Frank. We're ready to go on to the next section.
Next with us, we have Liza Horvath. Liza is the founder and CEO of Monterey Trust Management Services. She is a professional licensed fiduciary and is working as a trustee and executor. Previously, Liza was a regional trust manager and private banker with the Bank of America and Santa Barbara Bank and Trust. Prior to that, Liza served as a trust and estate paralegal for high values estates in Hawaii and California. Liza has a business administration degree from the University of Hawaii. She is a certified trust and financial advisor. She is an accredited investment fiduciary, a licensed professional fiduciary, a trained mediator, and has been an adjunct professor at the Monterey College of Law.
Hello, it's wonderful to be here and thank you so much for joining us. I wanted to first talk about, do we need a trust, and if so, what kind? There are numerous ways that we can get to where we want to go with regard to special needs trusts and serving those people that may need to have the trusts. A general will can establish a special needs trust. Additionally, you can use a revocable trust, and that can be either a separately standing trust that only addresses the special needs, or it can be a special needs trust that is set up if needed. As a professional trustee, I've worked with trusts where basically at the time the decedent passes away, we determine whether or not a special needs trust needs to be established. And that's based upon the needs of the beneficiary, of course, first and foremost, and then also whether or not the beneficiary is receiving public benefits, because we don't want to disqualify them from those benefits. So at the time, the trustee actually has the option to either establish a special needs trust at the time or not. We can also opt to do just a simple discretionary distribution trust where the beneficiary and the trustee work closely together and distribute funds as needed. As I mentioned, it can be a standalone trust or it can be something that is embedded within your whole estate plan. There are these documents that are called school district trusts. So if a child is in public schooling these days and the school is not able to really meet the needs of that beneficiary, then a trust can be established and the school actually funds the trust so that the trust can meet the educational needs of the beneficiary. A question that comes up very often when we talk about trustees and special needs trusts are the trustees' fees. Now that can be done a lot of different ways. If it's a court-supervised trust, then the court sets those fees. And they generally they top out at about $140 an hour. A private professional trustee can also charge hourly, and private professionals, if they're not under court supervision, will charge anywhere from $75 an hour up to about $250 an hour. If a family member serves as a trustee, they should also be entitled to receive fees because there's a lot of work involved, which we'll get into in a moment. A family member can also serve as trustee. Whether or not they charge fees is entirely up to them. If they are under court supervision, they fall within that $140 an hour presently by the court, or they can not charge fees. An ad valorem fee is the type of fee that we charge at our firm, and many professional trustees will charge an ad valorem fee, and that generally means that it's a percentage of the assets under management. The other way that trustees charge fees, and the way most professional trustees will charge fees, is something called an ad valorem fee. And that's an annual fee based on the amount of the assets that the trustee oversees on behalf of the beneficiary. For example, 1% per year is a pretty normal fee that a professional trustee would charge. And as I show here, 1% of a $500,000 trust equates to $5,000 a year or $416 per month. It's a flat fee and generally includes all of the services that the trustee will offer. When we want to talk about who you put in charge of the trust, remember, don't pit siblings against sibling. If they don't have a good relationship now, or if the relationship could become strained by appointing a sibling, choose not to. Find a professional or another family advisor that might be willing to serve in that capacity. It's important that trustees have certain qualifications. They need to have certain financial and legal acumen. They need to be able to read the trust document, understand it, and also take care of the financial pieces that are involved with the administration of that trust. They need to understand public benefits and assist the beneficiary on acquiring those benefits that they may be entitled to. They need to understand the needs of the beneficiary. They need to be able to gain the beneficiary's respect if a special needs trust is established for somebody who has a history of chemical dependency, those types of things. The beneficiary and the trustee have to come together and have mutual respect in order to be able to benefit the beneficiary by the trust. Finally, you need to think about succession. If the current beneficiary is young and you want somebody in that office for a long period of time during the beneficiary's lifetime, then you want to think about succession. So you can appoint a trustee now, and the document itself will say if this current trustee can no longer serve, they resign, perhaps they pass away, then there needs to be somebody else appointed in your document to step in. The trustee has certain duties that they must follow. They need to administer the trust according to its terms. As I mentioned earlier, they have to be able to read the document and understand it. They have to oversee the investment of trust assets. When you first establish a special needs trust, the beneficiary has to look at the current beneficiary of that trust, their age, their need in terms of discretionary distributions, and how long that trust needs to last. So they need to be able to invest those assets according to the needs of the beneficiary and make sure that they're prudently invested and appropriate for the trust. They need to stay within the terms of the trust and avoid disqualification of public benefits by the beneficiary. Let's talk a little bit about trustee liability. When you become a trustee of an estate, you become personally liable. That means that if you make a mistake or if you do something improperly with regard to the trust assets, your personal assets are on the line. As a professional trustee, we are able to get insurance that helps us in case we make a mistake or otherwise run afoul of the terms of the trust. Unfortunately, that type of insurance is not available to a private trustee. It's only available to professionals, so it's something that you really need to consider when you're thinking about who to put in that position. Finally, your trustee needs to be part of the team. You're going to have a team that helps address the healthcare needs of the beneficiary, the attorney that's going to help guide the trustee through the legal aspects of the administration, a tax preparer who prepares tax returns each year for the trust, and perhaps also helps the beneficiary with their tax needs. They need to have the trustee and the executor, and they finally have to have a money manager who will help them with those investments month to month and year to year. The last thing I wanted to touch on is something that often comes up with regard to the administration of trusts and estates, and that is to do yourself, do your beneficiaries, and do your trustee a favor. Make sure that they know where your legal documents are located, that they can gain access to those easily if needed, what your assets consist of, who your beneficiaries are and how to reach them, current contact information, plans for pets, if any, who your other advisors are, discretionary distributions, and information that you'll need included on the death certificate. Let me go back to discretionary distributions for just a moment. Generally speaking, trusts will say something like, I want my trustee to distribute principal and income for the benefit of my beneficiary for their health, education, maintenance, and support. That really encompasses a pretty wide variety of needs. One thing that we find very helpful is to make sure that the trustor, the person setting up the trust, has made us understand more about their thoughts. When you say education, do you mean private schooling? Do you mean private tutoring? What sorts of schools do you agree with? If your beneficiary can qualify for it? Do you want them to go to a semester at sea? Those kinds of things. Support also if you want them to have a new laptop every year, or do you just want them to have one laptop and make that last 3 years? All these small things help your trustee make those discretionary decisions on your behalf. A trustee's goal really is to make sure that we're doing what you would do if you were still here to do it. So it's helpful to have a little bit of expansion on what you would like included when you say discretionary distributions. Thank you so much for joining us today. It's been my pleasure. I hope you found this somewhat helpful. And I wanted to also thank Interim for the wonderful services they provide to our community.
Thank you, Lisa. Barbara, we have a question for you. How do you select a family member as a trustee for a special needs trust?
Well, just listening to what Lisa said, I'd be very careful about selecting a family member, and especially her consideration about using siblings and what it might do to their relationship. You might have another family member that might be a prospect for this that isn't as close as a sibling. Could be a cousin, could be an aunt or an uncle. You also have to consider the person's age if you plan for them to handle this after you as a parent are deceased. Thank you.
Thank you, Barbara. And I have a question for Frank. What's the difference between a special needs trust and a spendthrift trust?
Sure, those are two very different provisions. A spendthrift trust means that the money in the trust does not belong to the beneficiary, and so they cannot spend the principal themselves. A beneficiary can only spend the money that the trustee gives them or makes available to them. Most trusts, regular trusts, have these spendthrift provisions. A special needs trust, on the other hand, is designed specifically to make sure that a person's eligible for public benefits like Medi-Cal or SSI. So they are different types of trusts. Often a special needs trust also has spendthrift provisions or languages in it. Okay?
Okay, thank you. I have another question for Frank or Barbara. In your experience, do co-trusteeships work? For example, a family member with a professional?
Barbara, why don't I let you take that? You've had a lot of experience in this area.
I'm sorry, I've never seen a situation like that of co-trustees. I've seen situations where people are an advisor to a special needs trust, so that there's somebody appointed who can really consider the specific personal needs of the individual. And it may be a mental health professional that is the advisor to the trust, but isn't actually the trustee. But I've never seen a co-trustee situation.
And
Thank
I
you.
would add that in traditional trusts, often there are co-trustees, but I agree that in special needs trusts, they're not usually done that way because those responsibilities are very personal and it's difficult to have two people do one job in any situation. Thank you.
Yeah, that's a good point. It is always hard to get two people to agree on anything.
With us today, we have Judge Vanessa W. Vallarta. Judge Vallarta currently serves as the probate judge in Department 13 of the Monterey County Superior Court, hearing trusts, estates, conservatorships, and guardianship cases. She was appointed to the bench in December 2013 by Governor Edmund Brown. Prior to her appointment to the bench, she served as the city attorney in the city of Salinas and was in private practice in Salinas, Monterey, and San Francisco. Early in her career, she served as executive director of the nonprofit Center for Community Advocacy. She is a graduate of Princeton University and Stanford Law School.
I'm Vanessa Vallarta, the judge of the Superior Court serving in the probate department. It's good to be with you. One of the expressions that judges have is lifelong learning, and that's partly because we change assignments so much. We go from a criminal assignment to a civil assignment to a family law assignment and so on. And we constantly have to be learning. And one of the beauties of that is that it does keep you fresh and awake to opportunities. Since we were last together for one of these seminars, I think we've been through a lot together as a community, as a world, as a country. And of course, I'm referring to the global pandemic, the fires that have ravaged our county and others, and all the other things that are happening in civil society. It does really emphasize the role of the courts, which is to keep calm and carry on. We are still operating, we are still serving our community, we are holding court regularly and doing it in new and different ways like we all are. I also want to just emphasize what is the role of the courts and emphasize our mission statement, which is to adjudicate the cases that come before the court in a respectful, courteous, and efficient manner that promotes trust and confidence, and in the legal system by providing equal and open access to justice. The court handles a variety of case types, and I want to just give you the big picture. I handle wills and intestate succession matters. So you have a will. If you don't have a will, then your matters are handled through what's known as intestate succession. We also hear trusts, which are amongst the most challenging and interesting cases, and that includes what's known as special needs trusts that I know you've heard about from some of the other qualified speakers. In addition, we hear conservatorship matters, and those are, of course, protective proceedings for adults, including those with developmental disabilities. And then lastly, I also hear the guardianship calendar, and that is protective proceedings for minors, children up to the age of 18. If you are in the position where you think you might be coming to court, I'd like to speak today about 5 tips or 5 features that could contribute to a successful experience for you. The first is non-fear, or not being afraid. This is something very personal and something that you would know what is going to be best for your special needs individual, family member, friend. It's important in that context to be part of a community and get to know the professionals, those that work in this field, so that you can make the right decision for your family. Second, it's important to connect, and that is develop relationships with medical professionals, with other professionals that know about the needs of your family member or loved one. Those can include nonprofits such as Interim and other professional and private groups. Of course, it also includes the San Andreas Regional Center, which provides amazing resources to many of our community. Third important feature is to plan ahead and prepare. It's not a good idea to show up at court when you're not prepared, and also not to think several steps ahead and even generations ahead about what's best for you and your family. Fourth, be open. You need to really be creative sometimes, because the judge is going to have questions, other parties might have questions, family members might have objections. You really need to be open to alternative resolutions to things. And lastly, have courage to do what's right for you and for your family, and to fight for that. Let's talk about overcoming fear. So a lot of folks, when they come to court, often tell me, oh, I'm so nervous, and that's a completely reasonable place to be. You have to trust yourself. You know far more about your situation than anybody else does, and you are in the best position to explain that either directly to a judge or through your attorney. I would recommend, in the context of special needs trusts especially, but numerous other types of proceedings that I think you've already heard about, conservatorships, for example, it is very, very valuable to seek out the help of a qualified legal, professional fiduciary, financial advisor to help make those decisions. Stepping into a courtroom is not a decision to be taken lightly. There might be plenty of things you can do that don't involve stepping into a courtroom, and you need to weigh that decision very carefully, because it is expensive, time-consuming, and can last for a very long time. So if you're able to handle something privately on your own, that's often just as good an outcome for you. But again, we'll talk about why the court is also a very powerful tool as well. Court is a very formal, very technical setting. We deal with the probate code, which is thousands of pages, and it's really hard to know every nook and cranny of it, and that's why it's so valuable to work with someone who does know all the ins and outs. It's like a car mechanic who knows the ins and outs of an engine, and other professionals know the ins and outs of the probate code. The financial and accounting processes that are often brought into play are also very particular. A lot of people say, oh, I'm good at finances. Well, not until you've prepared an estate accounting would you know how technical and detailed those need to be and how they need to be prepared in a very particular format for the court to accept them. If you have decided to step into a courtroom to seek some assistance with your special needs family member, they can offer some amazing, powerful, and protective tools. So the second item that you need to think about is who can I connect with so that I can make the right decision for myself and my family member. I would encourage you to develop those strong relationships with family, with medical care providers, with the San Andreas Regional Center, if that applies to your loved one, and other support organizations such as Interim. They are a wealth of information and resources. Let me give just one small example about that. In the conservatorships of the person that Ms. MacDonald likely spoke about, you have general conservatorships, you have limited conservatorships. All of them require what's known as a capacity declaration. That is a very detailed questionnaire that's filled out by a medical professional. And that medical professional, if they know the person, can fill that out accurately, and they can give information to the court that really helps me make a decision about what I need to do with that individual. If the doctor knows you, knows your loved one, and actually has filled one of these out before, then it can be done correctly, and we don't have to continue the proceedings so that it is done right. The San Andreas Regional Center is another very valuable organization to make sure that you have a good relationship with all the care providers there. And they are the ones that are going to prepare a report for the court in the limited conservatorship with individuals that have developmental disabilities, autism, or other conditions of that nature. A third feature to a successful experience is to plan ahead. And we know that court is complicated and that if you're prepared, you're going to have greater success. When you are planning for your loved ones or yourself, you need to really be thinking not just this generation, what your intentions are, which of course is critical, but also several steps ahead. What happens if there is an illness? What happens if there needs to be the death of somebody that you've designated as a trustee? Who else can serve in that? Create a network of support for your loved one, and you will ensure that they have long-term success. Estate planning, very important function. A lot of folks don't do it. You know, they don't like to think about it, and we know this is hard. However, the more thoughtful you are about your intentions and how you would like issues handled for yourself and your loved one, the better off. A trust. So the trust that, of course, can be very beneficial for special needs individuals is the Special Needs Trust, which has evolved over the years and is a very highly technical document, but can serve an amazing resource for folks that meet the criteria for that type of trust, and it would allow them to continue to receive public benefits while protecting some assets for perhaps other needs that they might have. And so that's definitely something to consider. The conservatorships that have been spoken about also in this seminar, limited general of the person or of the estate. So depending on what the situation is with a particular person, I've had, there's legions of cases in court that involve elderly persons maybe that are being taken advantage of by scammers. It's a very common pattern, and the scammers know that, and they take advantage of those individuals to their great detriment. And there is a tool known as a conservatorship of the estate where you can protect an individual against that type of harm. Do you have a minor, someone that's under 18 years of age that might need special protection because their parents aren't around, or you know they're impaired, they're mentally ill, or they have substance abuse issues, what have you? Those children can be protected through the guardianship proceedings, and that's another avenue to consider. Again, as I've mentioned, plan several steps ahead. Think about who is your successor to the various positions that you might have. Choose wisely. And another thing to consider is fiduciaries. Ms. Horvath, I know, has spoken as part of this program. She's, one of the finest people we have in this county working in that field. Frank Hespy is another private fiduciary. There's really a lot of excellent folks that can serve as neutral individuals if it's too overwhelming for you or you'd just rather have a professional handle it. These are the kinds of people you'd like to be speaking to. And finally is be creative. There can be a lot of different solutions that can be developed to allow somebody to live in what the courts call the least restrictive alternative. So what does that mean? It's not living in a cage. It's not being completely restricted. It's how can we create safe but protective environments for folks either in their home or in regulated residential settings. So those are things to think about. Being open to alternatives is another tip that I want to just emphasize. There are many approaches to solving complex family issues, and the solution isn't always apparent at the beginning. However, sometimes through a court process, especially if there's objections, sometimes by the person who's the object of your petition. Sometimes we have proposed conservatees that don't want to be conserved. What does one do in that situation? Sometimes it's not apparent that they need that degree of protection. And in the course of that discussion, sometimes there are alternatives that might appear short of a formal court process or conservatorship. But I want to underscore how important a power of attorney can be, an advanced health care directive, the kinds of documents that you can take to a courtroom, to a doctor, to a bank, and you can conduct the business that you need to conduct. Representative payees are wonderful for folks that get Social Security or disability payments. Who needs to have a conservatorship of the estate? If you have a representative payee, that can be a very effective tool. Also, I've seen very successful cases where the San Andreas Regional Center, SARC, takes on the management of a person with a developmental disability. Sometimes when they don't have a family member who can step in, but that can be a very effective resource as well. Code enforcement can step in if somebody is hoarding and they're not taking care of their home. What do? You can contact your local city or county code enforcement officer and ask for a third party to step in so that you don't have to always be the heavy hand. Mediation is increasingly another very important tool that we're seeing, especially where there's a conflict situation in a particular case. And we have some retired probate attorneys who are doing some very fine work in that arena currently. And lastly, I want to mention restraining orders. There's a variety of restraining orders that are available. They're the civil harassment restraining order, domestic violence restraining order, where it's violence between family members, an elder abuse restraining order, where anyone over 65 is involved, and a gun violence restraining order. These are all very powerful tools where you can get in front of a judge in 24 hours and get orders including move-out orders. You can remove dangerous weapons from an individual who might be threatening themselves or others. Those are just very powerful tools that can also be deployed. I also want to mention, if you ever need help with any of this, there's another resource that is very valuable, the Self-Help Center, which is operated out of the courthouses in Salinas and Monterey. And you can call, you can email them and ask a question, how do I apply for a gun violence restraining order? There's also information on the court webpage about all of these things, Monterey County Superior Court. Lastly, have courage. It is important for you to fight for what's right for you and your family. You need to show up to court. A lot of people file things and then they don't come to court. That seems kind of incomprehensible, especially if you've paid hundreds of dollars to come, but sometimes people don't show up. And that's shocking to me sometimes, but it happens. When you come to court, be prepared. When you address the court, take a deep breath. Speak clearly. You know your situation. listen carefully to the questions that the judge might have. Try to answer her questions. She's trying to hear you and listen so that we can arrive at the best solution. If we both do that, then I think you're assisting the court in serving you, which is, in the end, our mission. Lastly, I'd like to just emphasize what is the mission of the Superior Court of Monterey County, which speaks to everything that we've been talking about in this seminar today. It is our mission to serve the public in a respectful, courteous, and efficient manner that promotes trust and confidence in the legal system by providing fair, equal, and open access to justice. If we are preventing harm and enabling our special need individuals to live healthy, more protected lives, then we are serving justice, and that is what we're here to do. Thank you.
Thank you, Judge Vallarta. Lots of good information there. I have a few questions here for our panelists. First one is for Frank. Is there a maximum amount of money that can be put into a special needs trust?
As far as I know, the answer is no. Some special needs trusts are quite large. A question comes up, though, if there is a very, very large amount of money, are you sure you want to put it in a special needs trust? Because if there's so much money that perhaps you don't need to worry about your loved one staying on public benefits because there's more money than they can use anyway, then you may not want to have all of the restrictions that a special needs trust requires. Again, these are the questions to talk with specifically about your attorney. Thank you.
Okay, thank you, Frank. Let's go on to our next speaker. Barbara Mitchell has a little presentation here.
Lastly, today we have Barbara Mitchell. She is the Executive Director of Interim Inc., and she will discuss the good work and important efforts that Interim Inc. has done for our community.
Thank you for joining us today for this presentation, and thank you so much to our presenters. I hope all of the presenters know how much Interim's clients appreciate the work that they do on behalf of people with disabilities in our community. For those of you who don't know us, Interim is the only agency that develops affordable housing and supportive services for adults with psychiatric disabilities in Monterey County. Interim's first project, a halfway house, opened in Monterey in 1976. Today, we operate more than 20 different housing and treatment programs in Monterey County. We employ more than 200 people, of which about 20% are our own clients. And we are continuing to grow. We continue to expand our treatment services, homeless services, and affordable housing. We're expanding medication support services through nurse practitioners and our psychiatrists. We also continue to develop more housing. In 2021, we will start construction on Sunrose Housing, which is a new affordable housing project in Salinas that will provide housing specifically for homeless adults with psychiatric disabilities. Special needs trusts like those that have been described today can provide additional financial support to adults with psychiatric disabilities. That is, of course, the first and most important priority. But they can also provide long-term, ongoing support for the types of programs that Interim provides. In the past few years, Interim has been very privileged to be named as a beneficiary of several bequests from former clients. The donations that Interim received through these trusts help us to purchase a building for the Omni Resource Center and helped us to build more affordable housing. Clients' quality of life was improved by a special needs trust while they lived. Thanks to the thoughtfulness of the people who established the trusts, important programs that supported consumers during their lifetime will assist future consumers of Interim services. You have received a wealth of information today through this presentation. If you would like to find out more about special needs trusts or about Interim, please contact Interim by emailing development@interiminc.org.
You can also find the address on the presentation slides. Thank you again for everything you are doing to help people with disabilities in our community attain happy, productive lives.
This concludes our seminar today. I wanted to thank you for joining us, and again, thank all of the participants for devoting so much of their time and energy on this very important and very timely topic. Thank you.
Okay, before everybody leaves to go listen to the debate, because I know that's something that I want to do, just be assured that we will send out a follow-up to everybody about including all of the questions that came in that maybe didn't get answered on the screen. Frank, do you want to take a minute, and Barbara another minute, to maybe sum up everything for our listeners today?
Sure, I'll start. I just want to say that taking care of your loved one is profoundly important, and it's very important that you do it the right way. As you have seen over the last 2 hours, there's a lot of moving pieces and a lot of different options available to you. Please make sure that you consult with a professional to make sure that you do it in the right way. Again, just for the love of the family member that you're worried about. And lastly, I just want to give a shout out to Interim for all of the great work that they do on a daily basis, and specifically to the staff for all of the incredible effort, energy, and creativity they put together to putting together this webinar. My thanks to all of you.
I just wanted to say thank you to everybody who hung in there and listened to this, and to our presenters who put in so much time putting this together. Our development officer, Deb Shearer, and our executive assistant, Jen Hardy, who spent so much time, and Chatterbox, who really helped put this together with Marcy and her staff. Thank you again. And we know we didn't get to all your questions. We will try and send out more answers. Thank you.
Thank you, Barbara. Just to touch base one more time, we'll say it one more time. We're here for you at Interim. If you have any questions or concerns about you or your family members with mental illness, and we're open Monday through Friday from 8 to 4:30. And you can call and talk to our staff about any concerns that you have. Right now, I want to thank Attorney Frank Hespy and Interim Inc. Executive Director Barbara Mitchell for this webinar. And thanks to our presenters, Carl Miller, Stephen Mudd, Christi MacDonald, Liza Horvath, Judge Vanessa Vallarta, and Barbara Miller. And thank you to Mag1 Media Salinas for their expertise in pre-recording all of the presenters. And finally, thanks to the Board of Directors who provided the final financial support for us to hold this webinar. Thank you to everybody who tuned in, and have a good night.